Yo, what's up, you guys? Today we're going to be reacting to the Young Thug trial, the Young Thug Rico trial for about for a few minutes, and obviously I'm not going to really do a long show because this is a very long episode. This is a very long live trial, so this video is not going to be that long. So just let's get into it. They haven't started yet.
Miss Hilton, what's the stage response as to those particular line and should say page and line references?
Wow. I do the portion here. The portions of this particular section, Your Honor, and it would begin on page 413 and 411, 14.
411, 14 through.
413.
Okay. What's the state's position? I'll decide whether I need to hear it or not. But
Your Honor, that this numerous personal knowledge about that there is his purpose was we had for memorize there is a conspiracy part of his theory in a number of instances that Mr. Zagreb was a strong purchaser for a number of guns that were recovered by YSL members, specifically the one gun that Mr. Cole has in his possession. In fact, the reason for the arrest that brought him into this interview was a gun that was.
Come to think about it, this is the judge that pretty much had an illegal ex parte hearing with the defendant and was basically exposed for it. Let's keep going.
Was purchased on his behalf. This section talks about where that purchase goes back and we believe that is relevant before the jury begins going the overall gang conspiracy in this case. It's not hearsay and what.
And so, if I can just respond,
yes, sir.
Briefly, and
Also, played prior to the contract. While there is a transcript, there are some things that are indiscernible that I can incorporate to listen to in here, and not just solely rely on.
I'm fine with doing that, and then perhaps I'll hold my commentary until after you further.
Okay, all right, let's play it, please. 411, 14 to 4, 1335. All right.
Why not come with his legal out there with that gun and not claim it? Leave my look. With the gun he got caught with. You said his motherfucker, why he wouldn't come claim it? But that's his big homie.
No clue why he ain't come claim. I thought it was in his name.
Two names.
I thought it was two guys.
That gun ain't nobody. It's in somebody's name, but it ain't in his name.
Yeah, it's not his name.
Well,
Yeah, he's happy it was. So he's happy it was.
shit, drug on it.
Local business owners. If you need more leads, more appointments, and more sales, I'll help you install an entire online lead generation system into your business in the next 90 days so that you can ditch the
The drug on it. It has a drug on it. I need to let you out of work. He get out of work.
He did.
What? What you put
Yeah, they could. Yeah. No, he did. And then they got steal this nigga right around these.
So he give it the D. So why would he give it?
He got another gun in the name. AK Dog got that.
Really?
Yeah.
When did he buy it?
In January.
It's back in January?
Yeah.
Where you got it from?
The same person.
No, sir.
Yes, he did. He got first class. He bought the AK first. To Draco.
He bought it from
He bought it first. He bought a Draco.
It ain't from there. It ain't from everything.
Shit, I don't know where he bought it from. He bought that price.
And he bought it from
No, he bought it himself, but sold it to it. Yeah, we were killing. So I jumped in for high price.
So what if y'all found a stolen gun? Y'all still tell it to him? You just tell him it's dirty or something?
He bought it out. He bought a stolen gun, a G gun. If I heard that still, I got something to get back. Man, right, everything.
Just because he got it.
So, again, Your Honor, this isn't Mr. Coleman's second statement. He is aware that one, put areas that purchased guns. Two, that he brought it from a pawn shop. Now, even when this detective
Dennis,
kept saying it's not from Arrowhead, he said, I don't know about Arrowhead, I know he bought it from a pawn shop. And then he further goes into say, no, he bought it from himself and sold it to Thug. We were joking. It was buying to sell to him at a higher price. And so this is not him speculating. This is him talking about purchasing guns. Again, both Quindarius Avery and Mr. Copeland are members of the larger gang, which is YSL. And the fact that they purchased guns is part of an overarching larger gang conspiracy in which the state is proving here. So this information is one, relevant, and two, it's not hearsay, it's not speculation.
have you already asked Mr. Copeland already about guns and the purchase of guns on direct in your direct? thus far?
I don't recall if I've asked about this. But again, the premise remains the same. You know, if Mr. Copeland is, as he said, court, making it all up to keeping everything up in this interview before to just get out of jail, this isn't something that he's this is not something that he is making up. This is something that the evidence will show that the detectives did is one, that they did find that Mr. Zachary had purchased the gun that he was found in possession of. They also got information from Cordelia Zachary about the guns that he purchased. So this is not him making it all up. As he said before, that everything he said, he was telling them whatever it is that he wanted to say. He's not giving this information up. So,
why would you think that it could be played before you ask the witness the foundational questions? I mean,
that's the same reason. It's not prior to say again, Your Honor, the premise, the reason why this video can come.
Yo, honestly, this judge sounds like a very incompetent judge. He sounds like a slouch. He sounds like a complete slouch. Let's keep on.
and I'm only going to let you go so far. Okay. I mean, I think you got to ask some questions in regard to that. I mean, if they haven't been asked, I'm not saying you can't ask it, play it. If you haven't asked them already about this, there's some foundation that needs to be played.
Well, we can impeach multiple different ways. The one way is impeachment by contradiction. Another way is impeachment by contradiction.
Okay. All right. I'm not inclined to let you impeach him by contradiction at this point because he hasn't testified about anything about any guns or anything like that. And you haven't asked him anything about any guns, which is what you just said. So if you had asked him about guns and then, he coupled with the potential not being truthful, you could probably, at that point in time, the foundation would probably be satisfied. I agree with you. You can impeach him many ways, but I think your foundation is lacking at this point. I'm just saying, if you're going to ask him that so you still got him on direct, you can ask him those questions, and then if he denies it or whatever else, then you may be able to get into some of this. So I'm going to exclude it at this point in time, Mr. Adams.
All right. Thank you, Judge. No argument on that then.
Okay.
The next one, Judge, page 419, line 10 through line 11. It's a line where this is the detective talking, suggesting that Mr. William and them is going to find out something about Copeland and, quote, knock your head off. He's talking to Copeland at that point. We've agreed, spoken to Ms. Hilton, we've agreed that that should be redacted.
Okay.
And I'll rely on Ms. Hilton to give us the time stamp on the video.
Let's see if we can get that. Ms. Hilton, now.
4/16/11.
Okay.
4/16/17.
4/16/11 to 4/16/17.
Yes, Your Honor.
Okay. All right. Continuing on. Go ahead.
The third one, Judge, is contained at page is pretty expansive. Page 421, line 16, goes to page 428, line. I have 16. We've agreed that it should go to 25. So that's going to be 421, line 16 to 428, line 25. That is a conversation, an extended conversation about someone named Kente and that person having people killed, about Kente and his brother robbing and killing other people. Numerous references to things said by unnamed individuals, references to persons potentially paying Mr. Copeland to kill someone, references to the relationship between some individuals and Mr. Williams, and assumptions of conversations that would have taken place between various individuals outside of the presence of the witness, Mr. Copeland. We have agreed in my conversation with Ms. Hilton that should be redacted.
Okay.
And as before, I've given the page and line numbers. If Ms. Hilton would be kind enough to give us the timestamp, please.
4/18/36.
4/18/36 through 4/25/32.
Okay. 32.
32.
All right. Next, sir.
Yes, sir. The next one we've not agreed on. This is on page 430, line 19 to page 431, line 17. And so in that one, and again, if I can keep my seat, I'll go ahead.
Yes, sir.
I'll read the relevant parts. There's a male speaker, and essentially it's a conversation about how Mr. Copeland got to know Mr. Williams, and what is said during that part of the transcript, starting on line 17. Male speaker asks, so how you hook up with Thug and them? Mr. Copeland goes on to say, I had what I had. He wanted some weed. He wanted, I think it says indiscernible. I think it says a zip of gas. Mr. Copeland goes on to say, and tick, like he pulls and rolling through. He come and get weed for him. I get weed for my brother. You feel me? Like he got the weed for $200. It cost $250 at the time. Mr. Copeland goes on to say, we took back up there. When we took it up there, Thug gave me the money for the weed. And then he gave me some money to put in my pocket. Gave Tick some money to put in his pocket. You know what I mean? And then I got around I just blended in and then started kicking with him. And when I started kicking with him and stuff, I think we were shooting pool. We got finished shooting pool and we left. And then out of the blue, he just called and asked for like we knew people that sell lean. You know what I mean? He started calling. He wanted different stuff. And I just knew the people who got Percocet and stuff like that, I used to just go take it to him. Okay, so that's the relevant part. I believe that is, number one, not relevant. And I want to kind of piggyback on something that Madam Prosecutor said earlier. When we were talking about one of the other statements, she said, well, that's evidence of, straw purchase of a gun. My point is, we've got an indictment. We've got an allegation of a conspiracy. And, we can't keep adding to the conspiracy by saying, well, there's something in the transcript or conversation that talks about, him buying Percocet or him buying weed. And so that's part and parcel of the overall conspiracy. It's simply not. There are some things that are just not relevant. I don't believe that, whether or not Mr. Copeland observed Mr. Williams, whether it's true or not, buying or smoking marijuana or buying or ingesting lean or Percocet, that's relevant to any issue in the case. It's certainly not relevant to anything that's charged. No specific indicted offenses, no acts of the conspiracy. So I think it's irrelevant. And I also think it goes to character. I think it's a comment upon Mr. Williams's character to insert that in the trial. It is certainly more prejudicial than probative. It's not probative of anything, quite frankly. No issue that's before the court or before the jury in this case. And so I would ask that be kept out. I simply don't think that it's relevant.
Okay.
And I'm sorry, let me just add to that before Ms. Hilton responds. I did want to address this whole issue because we keep coming back to it. That Mr. Copeland, who is on direct currently, one of the things he said is something to the effect of, I made that up. I made this stuff up. Well, that's not really carte blanche to impeach him with everything that's in his statement. We've already objected on behalf of Mr. Williams, and I think everyone else has, to the recording being played at all. But I just want to point out that she doesn't, if they're attempting to impeach him, you got to kind of pick and choose what you're impeaching him for. And you don't just get carte blanche because at one point he either says, I made that up, because he also said, yeah, I probably said that. You don't get to say we're going to impeach him by just playing everything and every single thing in the in his statement is relevant and comes in and is not subject to any other objection. So that's my position on that.
All right. Ms. Hilton?
Thank you. First, I want to address this issue part because the idea that we have to now reach a line by line. I believe that the courts have held that we don't have to keep.
Yeah. Why do I feel like some bullshit is about to come up out of this? Yo, I literally feel like some bullshit is about to come out of this trial. Like, for real.
Each line by line, especially when he's telling the court, telling the jury.
I think we covered that already.
But I do want to cite the court to a case, which is Skyner's v. States.
What is it?
318 Georgia.
What is it, madam? What's the name of the case? 318 Georgia? You said?
318 Georgia, 855.
Okay, and what's the name of the case?
Sconyers, SCONYERS v. State.
Okay.
And that's an April 2024 case, Your Honor.
All right.
And here it says, and again, this is focusing on prior inconsistent statements, but I think that it's instructive. In Division 3, near Head Note 8, it says prior inconsistent statements that meet the requirements of Rule 613B are not hearsay if the declarant testifies at trial and is subject to cross-examination. The failure of a witness to remember making a statement, like the witness's flat denial of the statement, may provide the foundation for calling another witness to prove the statement was made. Here, Finch's denials and alleged lack of memory of her prior statements and their contents were a sufficient foundation to allow other witnesses to testify about the content of those statements. That is the argument and the hitting. And it goes on to cite several cases where it cites Murdoch. It says see Nelms 313 Georgia at 788. See Bridgewater v. State, which the state addressed yesterday, which they cite or quote from Bridgewater. One witness's unambiguous denial that he had ever spoken with a second witness, as well as his assertion that he did not recall ever speaking with him, obviated the need for the prosecutor to ask the first witness about specific statements he made to the second witness and provided sufficient foundation for the state to present extrinsic evidence of such statements. Also citing Murdoch, which was 299 Georgia 177, a witness's prior inconsistent statements about a shooting was properly admitted under Rule 613B after she testified that she could not recall the details of the shooting itself or the content of her statement.
Okay, and stop right there, just if I can hijack you just a second. I don't have any issue with anything you said so far, and I think that you and Mr. Adams coexist in that space. However, the challenge you have is you've got to still ask the question about that area, and then I think it picks up from there. I'm not going to allow you to play it until you lay a little more foundation is for that reason. I'm not saying you can't play it, but you still have to give that witness an opportunity to be heard on that particular thing, asking about the gun, asking about that. So I think that what Mr. Adams is telling you and the court, the court kind of has some concern. That's why I asked you yesterday, was it discussed on direct? And you said, well, I'm going to check and see if it's discussed on direct. That's the predicate. So
if I could finish reading the next portion of Sconyers, I think that addresses the court's issue. Sconyers complains of the state's failure to confront Finch with the specific extrinsic evidence of her alleged prior inconsistent statements.
Okay, but you still have to ask him about the topic area.
So I want to get to the last portion. But
Okay.
as Bridgewater and Murdoch indicate, Finch's failure to recall making any statement at all about fighting, abuse, or anything like that, as well as her denial of the mall incident and Scania's arguing with Lincoln relieved the prosecutor of the need to ask about specific statements.
Okay.
So that is where we're focused at. The fact that he says, I made it all up, relieves the state from having to go line by line and asking about specific statements.
I don't have any issue with that. I don't. But I still think you guys, it's not like you have to give the witness an opportunity to confirm or deny. I'm not saying that. But I think as a matter of, you've got to orient the witness and tell him and ask him questions about the gun. You can't impeach him on a gun when you haven't even asked him anything about that. Yeah, you haven't, just based on, well, I don't remember. He hasn't even said, I don't remember anything about it. So, I mean, I think you need to introduce the topic. And then if he says, I don't remember, I don't recall, then you can do that. That's why I'm saying there's foundation and predicate. I don't disagree with the case law that you cited in Scania's but that's why I asked you has he testified as to that already? If he's testified about that and his memory's kind of, I don't know, I don't recall. Yeah, you can impeach him by prior contradiction or any other means that you think is appropriate under the circumstances. So I just want to make that clear. Okay.
Thank you, Ryan. So as relates to this particular portion of the interview, Mr. Copeland, I believe in court, when asked how did he meet Mr. Williams, said, I met him at the studio. I was kind of like a fan. What this portion of what Mr. Copeland tells the detectives back in 2015 is that this relationship kind of grew. It grew from possibly him being the person who facilitated giving him drugs to a more developed relationship, which was not just a fan. We have pictures of Mr. Copeland and Mr. Williams at each other's homes it looks like at their homes or respective places where they live. We have Mr. Copeland and Mr. Williams on tour together. And this evidence about the development of their relationship is relevant as far as character.
Haven't you gotten testimony about that already from the witness?
No, because he made it seem as though it wasn't a very close relationship. What he said is, I met Mr. Williams at the studio, and I was a fan of his.
Okay, well, how do you justify? I'm sorry, hi, Jackie. How do you justify then talking about him being purportedly Mr. Williams' go-between to acquire, illicit drugs?
So, Your Honor, again, we have charged in this indictment the fact that the members of YSL possess and sell and distribute narcotics. So this talks about that relationship. So this is relevant. This is already in the indictment. This is in the preamble of our indictment, Your Honor. Additionally, Your Honor, citing to two cases, Anderson v. State. State, 337 Georgia App 739, which is a 2016 case, as well as Moore v. State, which is 295 Georgia 709, which is a 2014 case. Your Honor.
Okay.
In both of those cases, it talks about relevant evidence as well as that evidence which incidentally places an individual's character into evidence. Your Honor, here in this case, there has already been testimony of Mr. Williams being stopped in a car with drugs. So this information with Percocet in 2017, I believe he was also stopped with marijuana inside that same vehicle. So this information about Copeland talking about Mr. Williams and how he met him is not anything that is more substantially outweighed by its prejudicial effect, because there's already evidence before this jury about Mr. Williams being stopped with drugs in his car, he's being stopped with guns inside the car. So the fact that Mr. Copeland is talking about this is how they met is not substantially prejudicial, and it is relevant to talk about the development of their relationship from being, whether it was his supplier of drugs, to a more developed friendship, which is more than what the witness indicated on the stand. And furthermore, Your Honor, I believe in opening statements, Mr. Steele, when talking about the relationship of Copeland and Mr. Williams, tried to distance Mr. Copeland from Mr. Williams. And I believe in opening statement, Mr. Steele tried to assert that Copeland was more friends with Demekion Garlington, in which they are friends, but really tried to distance what Mr. Copeland's relationship was with Mr. Williams. So I believe that the jury understanding the development of their relationship is important to assess whether or not they find what Mr. Copeland is saying in his 2015 interview credible.
So, Judge.
And I'm sorry.
Oh, I'm sorry.
And I just wanted to cite in Anderson v. State in Division 1, it states that it is well-established evidence that is relevant to an issue in the case is not rendered inadmissible simply because it incidentally puts the defendant's character at issue. And it cites to Jones v. State. Evidence is relevant if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. And it cites to 24-4-401. And while relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, exclusion is an extraordinary remedy which the court should invoke sparingly, and the balance should be struck in favor of admissibility. Furthermore, as a general rule, admission of evidence is a matter resting within the sound discretion of the trial court. And appellate courts will not disturb the exercise of that discretion absent evidence of its abuse. So, Your Honor, we believe that it is more relevant for an issue on hand. It is not more prejudicial, substantially more prejudicial than probative, because there's already evidence before this jury of Mr. Williams being in and around or associated with narcotics, Your Honor.
Are you finished? Madam, so I can let Mr. Adams respond. Ms. Hilton, you done with this response?
I may have Your Honor, after Mr. Adams.
All right, so
All right, sir.
I'll keep it brief, because I think maybe we sometimes have a tendency to conflate the issue. My objection is really very, very simple. That there's statements from Mr. Copeland about them either smoking weed together or him getting some weed from Mr. Williams or some lean or some Percocet. And my position is that that is irrelevant. That it doesn't go to any issue in the case. The fact that the indictment alleges that members of what they say is a gang were selling or engaging in the sale of narcotics is separate and apart from whether or not someone's smoking weed together. Right? I mean, just keeping it that simple. But moreover, if what they say the issue, what they really want is to get at the relationship. How did Mr. Copeland get to know Mr. Williams? That's what they said the issue is, and they say that this describes it. Well, that's not totally accurate, because I'll do what Ms. Hilton has done to put it into context. There's more in the transcript and in the statement that actually addresses that. If you continue to read over the next page or two in the transcript,
Starting from where?
Starting from page 431, line 19. You see Mr. Copeland saying, after a while, every time I go up there, he had me chill for a little minute and stuff. I never just go up there and then leave. He says chill or something. We carry over to the next page where Mr. Copeland says, and then after that, just started hanging with him. You know what I mean? Started putting my name in his songs and stuff, just like, oh man. Then we started hanging a lot. skip down a bit. He started taking me places and stuff. I appreciate everything you're doing for me. Like, it ain't no problem. That's how I started hanging. So there really is more in his statement that describes exactly what the state says they're looking for, how the relationship developed, what was the nature of their relationship, without us necessarily having to inject this character evidence about them smoking weed together or getting lean or getting Percocet into the trial. That's simply not a relevant issue. And so the argument, I think, that I hear the state saying, well, there's been other evidence of Mr. Williams being in possession of illegal drugs, and so this doesn't matter. Right. Well, it kind of does. That's like an argument saying, well, if someone is charged with a burglary and there's some evidence or some statements about the person committing other burglaries, that, well, we can let that in because, there's already been evidence about some other burglary. Well, you got to notice the defense if you intend to introduce other items or relevant similar items. You just call it similar transactions, 404B at this point. But that's my position. I'm trying to keep the issue simple. I think it's irrelevant. I think it injects his character improperly, and I think for that reason. And I also think that what they're looking for is contained in other unobjectionable portions of the statement, and so I'd ask for it to be kept out.
What about, Mr. Adams, let me answer this for me, if you wouldn't mind.
Yes, sir.
What about the issue in the preamble of the indictment where it says, that members possess, let's just say it's just offered for that particular reason? What would your argument be at that point in time? Because it's up to the jury to determine whether or not it's relevant. But I'll make a threshold determination. But whether or not it goes to anything,
right?
What would you say if I just said, well, it could be potentially admissible if just to show possession of illegal substances by YSL members, purportedly YSL members, because they have to first make that determination. But and then, of course, what it would be used for.
Sure. The preamble, to the indictment is really that's argument, right? What we get to, what they have to prove, and what we have to address is what's actually alleged in the indictment. What's alleged in the conspiracy, in the RICO count, and the specific acts, and we're put on notice by way of specific acts, and also by specific indictment numbers. Now, if they want to allege that Mr. Copeland and Mr. Williams smoking weed together at the studio is an act that is part of the overall conspiracy, then they allege it in there. But they haven't done that, because by that logic, really there's a lot of things that are said here by Mr. Copeland that aren't part and parcel of the indictment, but they can make the argument that, well, we said something about drugs in our preamble, and so all of that comes in. And I think that's essentially their argument, which I think does not control here. But my objection is just pretty straightforward, pretty simple. I think that is irrelevant.
That's definitely exactly what happened. They just turned around and heard the man say something about drugs and tried to connect it based off of that.
Your Honor.
Yes, ma'am. Mr. Knight.
Your Honor, the YSL organization uses criminal activities to expand their criminal networks. So the fact that Woody started off as a drug dealer, this isn't about them smoking weed in the studio. What it was is that he was bringing him the drugs, that the fact that he started off as a drug dealer and then was able to get into the gang itself or the organization and become an associate is a parcel of the larger RICO conspiracy. He went from not just the person who supplied drugs, but he moved on to a more associate membership relationship, again, talking about all of the portions that Mr. Adams just cited. So we transitioned from you bring me my drugs to now I have embraced you into our organization. Now you are a member of our organization. Now you can take trips. Now I can give you money in the club. Now you are a part of our organization. And I think that development in and of itself is important and relevant for the jury.
Well, that's a really good argument, and that's something good for closing argument. But that's, you know, and it's fine for them to have a theory, right? But just because they interpret it as such doesn't mean that there is evidence of that. You can't say that, well, him saying that we smoke weed together in the studio is evidence of him bringing him into a gang and them engaging in conspiratorial conduct. I mean, again, the state is fine to have whatever argument they want to have, but the court's determination is whether or not this particular piece of evidence is relevant, and whether or not it impugns Mr. Williams's character by its admission. I think it does, and I think it's unnecessary. page 457, line 2 to page 457, line 11. The next one I cited, and I'll give you all the time stamps over there. The next one I cited is page 463, line 4 to page 464, line 12, and then page 465, line 5 to page 465, line 7. The state is in agreement to having those redacted, but theirs is a little bit more expansive than mine. And so what we're actually agreeing to redact altogether is page 457, line 2, all the way to page 471, line 2.
All right, guys. I already told you this is gonna be a pretty long episode. So, but this is about the end of this. So, like, comment, subscribe for more content. Oh, and share. Share that button, guys. Trying to get up to at least about 1,000, at least about 1K. Like, comment, subscribe, and I'll see you guys later.